Peace and blessings. This is another mortgage checkup video, and in this video we're going to talk about the pooling and servicing agreement, aka PSA. Now, before we get to the points that you see before you on the screen, want to actually sort of explain a little bit about the pooling and servicing agreement, and also to point out that securitization litigation is really not understood by judges as well as lawyers. They really don't get it because it is a fairly new type of litigation. However, I'm going to share with you what I know, and in your research and protecting your property, your home, you may decide to use this strategy and use this angle. First and foremost, the pooling and servicing agreement, and I was blessed enough to receive some notes from an attorney that actually understands this, and this is what her practice is pretty much focused on: helping homeowners through litigation and so forth. Now, I'm not recommending that you go out and get an attorney. I am not recommending that at all. For me, I would not get an attorney, and I necessarily would not go through a public remedy process. I would do a private remedy process. So anyways, the pooling and servicing agreement, it is the contract that actually creates a residential mortgage, and it's backed in a securitized trust, and it establishes obligations and also authority of the master servicer and the primary servicer. The PSA is the root of all securitized-based foreclosure action defenses. Another thing, too, with the pooling and servicing agreement, I would not recommend this as a defense if you're currently in foreclosure. If you're currently in foreclosure, I would recommend a private remedy. However, if you're not in any type of foreclosure, you don't have a notice of default action pending against you, then the PSA angle would be a good offense. The PSA, it establishes that mandatory rules and procedures for the sales and transfers of the mortgages and mortgage notes from the originators to the trust. It is this unbroken chain of assignments and negotiations that creates the big problem. The primary purpose of securitization is to make sure assets, mortgage notes, are both FDIC and bankruptcy remote from the originator. So as a result, the common structures seek to create at least two true sales between the originator and the trust. So let's look at it like this. The most basic securitized structure has originator, which is party A, the sponsor is party B, the depository party C, and the trust party D. The other primary player is the master document custodian for the trust, and that will hereinafter we'll call the master document custodian MDC. So the MDC is entrusted with the physical custody of all of the original notes and mortgages and the assignment, sales, and purchase agreements. The MDC must also execute representations and attestations that all of the transfers really and truly occurred on time and in the required order, and that true sales occurred at each link in the chain. This is where the problem starts to come into play, because again, these entities out here, they feel that they're so big, you know, the whole too big to fail mindset, and they feel like they have the upper hand. They skirt around the law, and they don't do things according to the policies, procedures, and law that's in place. Section 2.01 of most PSAs includes the mandatory conveyancing rules for the trust and the representation and warranties. The basic terms of this section of the standard PSA is set forth. So 2.01 talks about, and I'm going to show you here these points that's on the screen. We're going to go through that, and I'm going to share with you a way to obtain your pooling and servicing agreement without having to pay anyone to do it. Again, as I shared in the other video, I don't necessarily recommend you going out and spending thousands of dollars for a securitization audit. It's up to you, but I'm just saying I don't recommend it. There's lots of other angles or strategies that you can utilize depending on you know, where you are in the process with your home. If you're current, everything's good, you don't have any actions, foreclosure actions pending against you, then you know you've got lots of options. If you're in foreclosure, then again my recommendation is a private remedy. And this actual process here that we're talking about is really a public process of litigating and arguing from the standpoint of your PSA. Once you have a copy of that, it's really it's intended for a public remedy. What I mean by public remedy is going into the public courts before a judge and arguing the points. However, if you're really knowledgeable, then this entire remedy can be taken on the private side as well, and not utilizing the public court system via contracts. Okay, so 2.01, conveyance of mortgage loans. This is inside of the PSA. Part A, the depositor concurrently with the execution and delivery hereof hereby sells, transfers, assigns, set over, and otherwise conveys to the trustee for the benefit of the certificate holders without recourse all the right, title, and interest of the depositor in and to the trust fund, and the trustee on behalf of the trust hereby accepts the trust fund. Part B, in connection with the transfer and assignment of each mortgage loan, the depositor has delivered or caused to be delivered to the trustee for the benefit of the certificate holders the following documents or instruments with respect to each mortgage loan so assigned. I, or that may be Roman numeral 1. The original mortgage note, except for no more than up to 0.02% of the mortgage notes, for which there is a lost note affidavit and the copy of the mortgage note, bearing all intervening endorsements showing a complete chain of endorsement from the originator to the last endorsee. Endorsed, open quote, paid to the order of blank without recourse, close quote, and signed in the name of the last endorsee. What this is telling you here is specifically how these notes have to be assigned and or sold. To the extent that there is no room on the face of any mortgage note for an endorsement, the endorsement may be contained on an along unless state law does not so allow and the trustee is advised by the responsible party that state law does not so allow. Let me get my Black's Law here and tell you what along is. I know what it is. It's like an attachment, but let me allow Black's Law to tell you. Hang on. Okay. Along. This is from Black's Law 6th edition. A piece of paper annexed to a negotiable instrument or promissory note on which to write endorsements for which there is no room on the instrument itself. Such must be so firmly affixed thereto as to become a part thereof. UCC 3-202 parentheses 2. That's what a long means. Legal definition. If the mortgage loan was acquired by the responsible party in a merger, the endorsement must be by last endorsee, successor by merger, to the name of predecessor. If the mortgage loan was acquired or originated by the last endorsee while doing business under another name, the endorsement must be by last endorsee, formerly known as previous name. That's out of Section 2.01 of most pooling and servicing agreements. Now, if we look at and we review all of the recent standing and real party and interest cases that's been decided by the bankruptcy courts and the state courts in judicial foreclosure states, all arise out of the inability of the mortgage servicer or the trust to prove up an unbroken chain of assignments and transfers of the mortgage notes and the mortgages from the originators to the sponsors, to the depositors, to the trust, and to the master document custodian for the trust. So as we referenced and we talked about in the PSA, the parties, have represented and warranted that there is a complete chain of endorsements from the originator to the last endorsee for the note, and the MDC must file verified reports that in fact holds such documents with all intervening documents that confirm true sales at each link in the chain. Interesting stuff here. So the complete inability of the mortgage servicers and the trust to produce the unbroken chain of proof along with the original documents is really the genesis for all the recent court rulings. You may think a simple request to the master document custodian would really solve these problems, but a lot of cases reveals, a massive volume of transfers and assignments executed long after the closing date, of course. So it's like, jumping around from party A directly to party D, which cannot legally occur. Remember we talked about the chain of assignment. It cannot be broken. So there's a lot of different points. There's a lot of different defenses and counterclaims that are related to pooling and servicing agreements. And it was shared with me about 16 different points, and I'm not going to read all of these, but I will include these points in the description section here of the video. Okay, so now let's take a look at what's on the screen. This is how you can request a certified copy of your pooling and servicing agreement for your particular mortgage. And these are the points that need to be included in your request. The first point is what securitization trust your loan is in. If you know this, and I'll give you a hint, it's a goofy looking number. It looks like a trust number. It may say, 3 letters, TLC 2005-1 point something. They would be listed as your lender or investor or holder, just depends. But that is the securitization trust number. If you don't know what it is, then just leave that blank. The original lender. This is the original lender in your closing documents that's listed. And if you don't have your original closing documents, then you need to go down to your real estate county registrar's office and you need to request copies on your property. And it's a good thing to do that periodically as well, because you may find some liens there that you weren't aware of. So it's a good thing to do that. But that's where you'll find that in your closing documents. Your servicer, you're going to list out who that servicer is. The MIN number, this is the MERS identification number, or some people call it mortgage identification number. It is 18 digits, and it is on the first page of your security deed of trust, or mortgage. It's on that first page. Loan numbers. These loan numbers, they can be changed, of course, when the loan is transferred or whatever. So any applicable loan numbers that's in your documents, or also in the documents that you get down at the county registrar's office, put those numbers there. And you'll see there, next point, alternate loan numbers. City, state, and zip of the property, date of origination. This is the closing date, not the date that your documents were filed at the registrar's office. This is when you sign, the closing date. The type of loan, first, second, pay option, 5-year ARM, etc. Put all that there. First payment amount, put that there. If it was interest only, fill that out. Full principal and interest payment, put that there. This is all the information that they're going to need to research and actually find your PSA. The beginning interest rate, answer that. The loan amount, answer that. And then the last 4 digits of Social Security numbers. And this is going to be, if you had a borrower and a co-borrower, then you would have 2 last 4 digits, and you'll just put the person's name in parentheses. If there were only one borrower, then you would have just 1 set of numbers and name. So once you have those points, then what you will do is send all of those points directly to certified@sec.gov, and you're going to request a certified copy of the pooling and servicing agreement. Now, I was given these additional emails as well that people have been using, and basically these are people in the SEC that directly work with pooling and servicing agreements. And one is Christina Sarahan, and her email is there, sarahan@sec.gov, and Larry Mills, whose address is millsl@sec.gov. And you can expect about a 30-day delay in receiving an email back. If you don't receive a confirmation email within a couple of days or whatever, then we advise you to go ahead and send a follow-up email. And again, I'm going to place all of these points and the documentation that they're going to need. I'm going to put this inside the description of the video so you can easily copy it. And this is also just for your records. This is an address from where the records will originate, so that's for your information there. So again, this is a strategy that I recommend a person utilize on the offensive, meaning you're current on your payments, you don't have any pending foreclosure actions and everything like that. I would recommend this option. If you're currently in foreclosure, I would recommend private options that work a lot better than public remedies. So that's it for this video. Hopefully it's been helpful to you. I'll see you in the next videos. Leave a comment below if you so desire. Take care. Have a great day. Peace and blessings.